Morning. Oops, I've got to, unmute. There we go for that feedback. Let's say good morning again.
Good morning.
And welcome to the EPC meeting for February 17th. Commissioner White, our chaplain, will lead us in the Pledge of Allegiance and an invocation.
Thank you, Madam Chair. I'll ask that everyone please stand at this time. We'll begin with the Pledge of Allegiance. Attention, salute, pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Heavenly Father, we are thankful for the clean environment that we have here in our hometown of Hillsborough County, Florida, and for our environmental treasures that we have here. And we're also thankful for industry and commerce that allows us to have food on our table and provide for our families. And we pray that you will guide this board and our staff and stakeholders as we make decisions today that seek to keep those things in the proper balance. And as always, I pray for our armed forces and our first responders. Pray that you will guide them and keep them safe each and every day. And I give these thanks and ask for these blessings in your heavenly name. Amen.
Amen. And at this time, clerk can take the roll.
Smith?
Here.
Kemp? Cohen?
Here.
Hagan?
Here.
Myers?
Here.
Overman? White?
Here.
Thank you. You have a quorum.
Thank you. Ms. Doherty, do we have any changes to the agenda?
No, Commissioner, we do not.
All right. And no recognitions and proclamations today?
No, Commissioner.
And I'm informed there's no public comment. No one has signed up for public comment. Is that still?
That's correct.
All right. So that takes us straight to the consent agenda.
Move the consent agenda.
Second.
Thank you. We've got a motion to approve by Commissioner Cohen, second by Commissioner Myers. We'll take a roll call vote because we are hybrid today.
Smith?
Yes.
Cohen?
Yes.
Hagan?
Yes.
Myers?
Yes.
White?
Yes.
Motion carried 5-0.
Thank you. So moving right into the regular agenda, Ms. Doherty, you want to start us off?
Yes, Commissioner. The first 9A is an overview of the Florida Department of Environmental Protection 404 Assumption Program, and that presentation will be given by Christina Bryant.
Good morning, Commissioners. My name is Christina Bryant. I'm with the Wetlands Division of EPC, and I'll be providing you an overview of the DEP 404 Assumption Program. For this presentation, I am going to turn my camera off so that the focus will be on the slides. I'm here this morning to provide you a brief overview of the State 404 Assumption Program and how EPC continues to coordinate with federal, state, and local agencies to ensure the protection of our wetland resources here in Hillsborough County.
Christina, just so you know, we are not seeing the presentation yet.
Uh-oh.
If you'd like, we could share from this side.
Let me do one more. Okay, what about now?
Now we are seeing it. Thank you.
Okay, wonderful. My apologies. The Clean Water Act creates the framework for regulating discharges of pollutants into waters of the United States. The Assumption Program deals specifically with Section 404 of the Clean Water Act. Section 404 requires that a permit be obtained before conducting dredge and fill activities in waters of the U.S. And I'll talk a little bit more about waters of the U.S. later on. DEP applied for and was granted delegation from EPA to assume certain federal permitting authority in Florida regarding dredge and fill activities. Assumption is not a common program. There are only 2 other states that have obtained assumption from EPA. Michigan obtained assumption in 1979 and New Jersey in 1987. The process for Florida to obtain assumption started in 2018. On December 17, 2020, EPA approved Florida's program, and the program became effective on December 22nd, 2020, when the approval was published in the Federal Register. The purpose of the 404 assumption is to provide a streamlined permitting process. Both federal and state authorizations are obtained from one agency. This allows the state more control over the natural resources, as they would traditionally be more familiar than the federal agencies. Commissioners, sometimes there's the perception that when streamlining takes place, there's a loss of protection. This is not the case with the 404 assumption. Florida adopted the federal standards and requirements into state rule. DEP is required to follow the guidelines set forth in rule and the guidelines of the program as approved by EPA. There's actually a split of duties. The Army Corps will retain oversight of certain water bodies, generally speaking, navigable waters such as rivers and tidally influenced areas, while DEP assumes permitting responsibility for all other waters of the U.S. It does bear mentioning that this is a large undertaking by the state, and as with any delegation, there is a learning curve. Even with the challenges, the protection of the natural resources is what's most important. For the next part of the presentation, I'll delve a little bit deeper into how this is accomplished. The 404 assumption only applies to a subset of surface waters and wetlands. These are called the waters of the U.S. or WOTUS, and are water bodies that fall under the jurisdiction of the federal government. While it seems like this should be very straightforward, what is and is not considered WOTUS is actually a controversial topic and is ever evolving. Even though the definition and criteria of what is considered a waters of the U.S. vacillates, in Hillsborough County, all of our wetlands continue to be protected because of our local wetland rule. To be clear, the 404 assumption program does not prevent EPC from continuing to oversee wetlands in Hillsborough County. The picture on your left is an example of an isolated wetland. This would not be considered a waters of the U.S. and thus not jurisdictional. The picture on the right is of a wetland system adjacent to a navigable water body and would be considered WOTUS. But again, in Hillsborough County, that distinction would not matter because all of our wetlands are protected. Now let's talk a little bit more about what assumed and retained specifically means. The Army Corps retains permitting jurisdiction over the navigable and tidally influenced water bodies. In addition, there's a 300-foot guideline or buffer associated with these waters. If dredging or filling is proposed within retained waters, the 404 review will be conducted by the Army Corps. If a water is not retained for purposes of review, it is considered assumed. If dredge or fill is proposed in assumed waters, the 404 review is conducted by DEP. To assist the applicants with determining if a water body is retained or assumed, an interactive map was created and posted for public use. This is a screenshot of the map the public has access to in order to determine if they're in retained or assumed waters. Again, this is only applicable if the applicant is proposing dredge or fill activities. For the purpose of this presentation, we did darken the purple to make it stand out more. If you actually go to the site and access the map, it's purple crosshatching to represent the retained waters. So for someone who lives along the Alafaya or in Apollo Beach and they're proposing dredge or fill activities, the 404 permitting would fall to the Army Corps. EPC has a delegation agreement with DEP to issue certain environmental resource permits in Hillsborough County. Again, to make sure we're all on the same page, this is not the same as the 404 assumption that the EPA delegated to DEP. I would like to note that before continuing, due to the EPA requirements of the 404 delegation, wetland lines must be verified by certified DEP staff. This has been a concern within the regulated community. Commissioners, even though EPC is not able to set a formal line for the state, we are able to set binding lines pursuant to our local rule, which is recognized, our lines are recognized and accepted by Hillsborough County Development Services. Our lines are used by developers or even single-family homeowners to continue in their permitting process. The Wetlands Division staff utilizes the same methodology as the state per rule. We make every effort to coordinate our environmental reviews with DEP. For example, if there was a single-family home where it is in assumed waters and they may need to fill or dredge, EPC would review the environmental resource application and then notify the state. The DEP would still issue and review the federal 404 authorization. With regards to retained waters, again, these are areas that the Army Corps has jurisdiction over. In addition to Section 404 of the Clean Water Act, Army Corps also has jurisdiction to regulate structures such as docks under Section 10 of the Rivers and Harbors Act of 1899. In tidally influenced order bodies in Hillsborough County, EPC has a coordination agreement with Army Corps to review proposed work on their behalf. We maintain a close working relationship with our local Army Corps office, which happens to just be minutes from our location on Falkenberg. Pictures are always helpful, and these are examples of projects. A seawall on a residential canal would be located in retained waters. In Hillsborough County, this would be reviewed by EPC on behalf of Army Corps pursuant to our coordination agreement. In addition, we would review for DEP for the environmental resource permit, and then also for Port Tampa Bay pursuant to our delegation agreements. In terms of a dredge, it often brings up large-scale projects, such as deepening waterways for ships. However, dredging can be proposed from a single-family home perspective in order to have adequate depth to navigate vessels. I have provided a summary background of the 404 Assumption Program, and with my remaining time, I will talk about what this means for EPC and the citizens of Hillsborough County. Even with the implementation of the 404 Assumption Program, there are certain permits EPC will continue to issue on behalf of the Department of Environmental Protection. Some of them do involve dredge and fill, and when that is the case, EPC notifies DEP and starts a coordination process. When possible, joint site visits are conducted and information about the project is shared, all in hopes of making the process as seamless as possible. However, it is key to note, again, EPC does not have 404 delegation, and we do not issue the 404 permits on behalf of DEP. In the future, there may be opportunities to further assist DEP in certifying wetland lines. To that end, EPC is forward-thinking, and we have 2 staff members that have been deemed certified wetland evaluators by DEP, and several other staff who are well on their way of working towards certification. The Wetlands Division offers one-stop permitting for hundreds of applicants each year. Not only do we issue permits on behalf of DEP, but we have a delegation agreement with Port Tampa Bay and a coordination agreement with Army Corps, all in efforts of making a streamlined permitting experience for the citizens of Hillsborough County. In closing, our agreements are what allow us to provide this streamlined permitting process. Local protection of all wetlands in Hillsborough County remains unchanged. EPC's mission is to protect our natural resources, environment, and quality of life in Hillsborough County. It is our goal that the legacy of environmental excellence will be clearly seen in the landscape of Hillsborough County for all generations to come. Thank you for your time, and I'll be glad to answer any questions you may have.
Thank you. That was a very good presentation of a complicated layering of the protections that we have. But I will just say I'm always impressed about how fortunate we are here in Hillsborough County to have EPC locally overseeing and protecting our wetlands with the history of experience that we have in that agency and the real fine-grained understanding of how our wetlands are connected. I remember, in fact, I was thinking during the presentation about when they were, when she was talking about connected and unconnected and navigable waters, I was reminded of J. Del Kerr, a previous wetlands director at EPC, who was so diligent and passionate about protecting our wetlands. And she used to say, really, all wetlands are connected, you know, essentially. Commissioner White, you're recognized.
Thank you, Madam Chair. So with respect to that retained versus assumed category, are all the rivers in Hillsborough County in the same category then?
I believe so. Christina, can you address that?
I can. So anything that is tidally influenced would fall within the retained category, and any activities proposing dredge and fill would still be under the jurisdiction of Army Corps.
Got it. And I'm probably getting into the weeds and probably about to ask a question that's probably pretty technical, but at what point in the river do you decide, or determine, decide's not the right word because that's a subjective term. At what point in the river do you determine that the river's no longer tidally influenced?
So for the purposes of the 404 permitting, those decisions were made by the Army Corps and EPA. Those are items that are provided within the layers, and so it was not something that was determined by DEP or even, of course, EPC staff. That was something that was provided as information, and so they made those determinations.
Very good. So on that interactive map, then it's pretty easy to get a view of that, right?
Absolutely. You can go in and type in the address, and then you can zoom in. You'll be able to get a clearer understanding of where exactly the demarcations are, And of course, our local office is definitely extremely helpful. We have some areas sometimes where it's a little bit unclear when we're looking at them, and we just reach out to the local Army Corps office and we say, okay, this is where we are. What's the determination? Would this be, tidally influenced? Is this going to be retained, or would it be assumed? And they get right back with us.
Very good. Thank you so much.
You're welcome.
Thank you. And seeing no further questions or comments by board members, thank you very much, Ms. Bryant, for an excellent presentation. Ms. Doherty, you want to introduce the next item?
Absolutely, and great job, Christina. The next item is 9B. It's to initiate a revision to Chapter 5 of the basis of review, and it's Sterling Woodard will just make a few quick remarks about that.
Yeah, good morning, Commissioners. Sterling Woodard, EPC staff. I'm just here to let you know that over the next several months, we're going to be looking at revisions to our Chapter 1-11 basis of review, which is Chapter 5 of that basis review, but it's tied to our wetland rule, Chapter 1-11. And that Chapter 5 of the basis of review is basically guidance to the public on what's the criteria for trying to comply with miscellaneous activities in wetlands rule. That's primarily mostly building of docks and boardwalks and other types of things that may have a minor impact, in a wetland. We came to you last year, I think in May, and made some revisions to our basis of review. And we cleaned up and clarified a lot of the issues with it, but we also added a bunch of exemptions to make it more consistent with the DEP, SWIFMUD, and DEP and some of the other regulatory agencies who have similar types of exemptions. So we were actually trying to make it more streamlined and more easier for the public to actually do what they do. But once we implemented it, we got a bunch of comments from some of the consultants, even though we had public workshops and met with them. We got a bunch of comments from the consultants and the public who asked for some clarification. So what we did is we got together with our staff and we've been looking at some minor changes to it. They're not expected to be extensive, but some of the things that we're actually looking at doing is refining some of the criteria for like building a fence or some kind of a walkway in a wetland, including some clarifying language for government entities that want to do like nuisance and plant removal, like the city of Tampa did earlier this year, where they wanted to actually remove some nuisance species around the water treatment plant on the Hillsborough River. And then we also want to look at things like marginal structures, because even though we created exemption criteria, if you bundle docks and boardwalks and other things together, you may actually not be able to comply with some of the exemption criteria. So we wanted to clarify a lot of that language, that when we were trying to exempt some of those things from the rule, we actually wanted to try to clarify it and bundle it together. So even though we're not asking for a vote, and this is just an informational, we just want to let you know that we're going to be moving forward with, this rule work, and we'll be back to you probably in the next several months to look at some of those revisions once we have some workshops with the public.
Thank you, Sterling. Appreciate it.
Thank you, Mr. Woodard. This is another example of why it is so, we're so fortunate to have local oversight, and that we can be flexible with our local constituents and the regulated community. And it's also an example of how when we make the big decision to change the basis of review in May, we can always come back and tweak that when we see how it's actually being implemented, what are the actual consequences, maybe some unintended consequences, boom. 6 months later, we're looking at tweaking it a little bit around the edges to fine tune it. And, that's the promise we make when we make like a big comprehensive plan change. And people are bringing up these specific what ifs and hypothetical little situations. We can, with confidence, say, don't worry, we're going to see how it's working. If it's not working, we can come back and adjust. And this is a perfect example of that, to put people's mind at ease when we are making changes to the rules. So seeing no further questions or comments by the board members, Ms. Doherty, you can move us to the next item. And thank you very much, Mr. Woodard, for a good introduction to that.
You're welcome.
Yes, Commissioner, I couldn't agree more about the tweaking, and we had a lot of stakeholder workshops before that last change, and we'll have stakeholder workshops and public workshops again as we tweak it. The next agenda item is 9C. It's a legislative update. I sent out the FLARA update to all the commissioners that listed all of the bills in detail, and you can even click on there and get even more detail. But we're just going to touch on a few of them, so I'll call Beth Lee up to give you the legislative update.
Morning. Good morning, Commissioners. My name is Beth Lee, an attorney with the EPC Legal Department. Today, one second, okay, so I apologize for that. So today I will be providing a brief legislative update for this current 2022 legislative session. The legislative session began on January 11th and will conclude on Friday, March 11th, 2022. As you know, the Commission has empowered the Executive Director and Commission Chair to monitor, lobby, and comment upon bills that may affect EPC authority. The EPC Legal Department monitors each session, and this will be a brief summary of a few notable bills that we are tracking. Many of the bills tracked by our department are environmental in nature, but we also track administrative bills. This first set of bills, titled Local Ordinances, affect the rulemaking procedures of cities and counties. These new rulemaking procedures will require cities and counties to produce a business impact statement on a proposed ordinance, which includes the estimated direct economic impact, the number of businesses likely impacted, and any additional information deemed useful. The bills also require the suspension of any ordinance once it is challenged by a lawsuit under certain conditions. If the ordinance is successfully challenged in court as arbitrary or unreasonable, the government would owe attorney's fees to the prevailing party. Included in the committee substitutes are numerous exceptions to when a business impact statement is required when enacting a new ordinance. Among these exceptions are ordinances enacted to comply with state or federal law, emergency ordinances, building code and fire prevention code ordinances. Additional exceptions include ordinances related to implementing a contract or agreement, the adoption of a budget or budget amendment, and growth policy, county and municipal planning, and land development regulations. Senate Bill 280 and House Bill 403 would make it easier for Florida businesses and individuals to challenge local ordinances. And currently, the Senate bill has passed with committee substitute at the end of January, and it is in House messages. House Bill 403 has passed its second committee. This second set of bills is the Local Business Protection Act. These bills would create a new cause of action for Florida businesses to challenge local government ordinances or charter provisions that they believe will harm their profits. Senate Bill 620 would allow businesses that have been established for at least 3 years to sue local governments over ordinances if that ordinance will cause a 15% or more loss in profit. Similar to eminent domain actions and claims under the Burt J. Harris Act, a business is required to submit a demand letter with a written offer to settle with the government prior to filing suit. A county or municipality also have the opportunity to cure by repealing or amending the ordinance. If a business does file suit, the ordinance would be suspended until the case is resolved. Judges would have the option of requiring governments pay the business's legal fees if the court strikes down the ordinance. The amount of business damages that may be recovered by a business may not exceed the present value of 7 years lost profits or an amount equal to the business's gross receipts for 60 months. Exceptions have been incorporated similar to the local ordinances bills just discussed. These, for example, include charter provision, ordinance and charter provisions enacted to comply with state or federal law, building code and fire prevention code. And additionally, a county municipality is not liable for damages after enactment of emergency or temporary emergency ordinances, ordinances related to implementing contract and agreement, or the adoption of budget or budget amendments. Senate Bill 620 passed the Senate with a 22-14 vote, and House Bill 569 has one more committee stop before being heard by the whole chamber. This next topic is the Dangerous Tree Preemption Bill. There are 2 sets of bills currently in the legislative session. As you are aware, the Dangerous Tree Preemption Law passed in 2019 legislative session, preempting a local government from restricting or conditioning the removal of dangerous trees on a residential property. Since its enactment, what constitutes as residential property or dangerous was unclear by the regulated community. The first set of bills, Senate Bill 316 and House Bill 6025, proposed to repeal the statute entirely, where in contrast, Senate Bill 518 and House Bill 1555 proposed to clarify the areas which were identified by the regulated community and local governments as unclear. Specifically, both bills define residential property as a single-family detached building and require the use of International Society of Arborists standards to determine when a tree constitutes an unacceptable risk. So the change from dangerous, which was unclear, to unacceptable risk, which will now be used by professional standards. The EPC Wetlands Division authorizes the removal of hazardous trees under a miscellaneous activities and wetlands permit. This law preempted our authority to authorize this activity if the activity met the statutory requirements. The repeal of this preemption would strengthen EPC's authority for this activity, but alternative Senate Bill 518 and House Bill 1555 would help clarify where the preemption ends and EPC's authority begins. The set of bills proposed to repeal the law have only been heard of one of the 3 committees, and Senate Bill 518 and House Bill 1555 have each passed 2 of their 3 committee referrals. The proposed repeals bills, I apologize, I misread my notes, but the proposed repeal bills have not been heard by any committees. The second to last set of bills that I'll cover with you today is the Pollution Control Standards and Liability. As filed, House Bill 909 and Senate Bill 1210 would have provided a presumption of compliance for pesticide application on current or former agricultural lands and contained extensive preemptions for local governments from conducting site assessments and providing remedial activity requirements. The original bill named Development of Current or Former Agriculture has since been changed to Pollution Control Standards and Liability. After committee review, House Bill 909 and Senate Bill 1210 were drastically revised and limited the preemption language. Now, the 2 bills propose that FDEP is to have exclusive jurisdiction to set the standards and procedures for evaluating and assessing liability for contaminants on agricultural land. It's important to note that the preemption is for setting the standards and procedures. This is important because the bill language specifically identifies that exclusive jurisdiction does not prevent a local government's enforcement authority under a local pollution control program like EPC. Another way the bills were revised and lessened their preemption significance is that it is now limited an application to only those lands currently classified as agriculture being converted to a non-agricultural use, and not those lands which were formerly classified as ag. Prior to the bill's revision, EPC staff provided county staff feedback on how these bills could have affected EPC authority. With the committee substitute changes, the language is now more favorable. Currently, House Bill 909 has passed 1 committee and will be heard by its 2nd committee potentially this afternoon. Senate Bill 1210 has passed 2 of its 3 committees. These last set of bills affect the regulation of PFAS, or perfluoroalkyl and polyfluoroalkyl substances. PFAS and PFOS are man-made chemical compounds developed to provide oil and water repellency, chemical and thermal stability, and friction reduction. Commonly used as a fire retardant, their use began in the 1950s, and although phased out, they remain present in the environment as they move easily through soil and water and can accumulate in fish and wildlife. House Bill 1475 requires FDEP to create statewide cleanup target levels for soil and groundwater contamination of PFAS substances by 2023. This is helpful because currently state rules do not have a cleanup target levels for PFAS, only screening levels for detection exist. In application, if a property is only contaminated by PFAS substances, the property may not qualify for certain remediation programs because there are no cleanup target levels to require the specific remediation. Setting cleanup target levels would also provide local pollution control programs like EPC the ability to point to a set of state standards to apply in a local cleanup and site remediation program. Senate Bill 7012 would establish the task force within FDEP, which, among other things, would recommend the cleanup target levels for PFAS for rulemaking purposes and would recommend how to assess liability and financing for cleanup. House Bill 1475 has passed 2 of its 3 committee referrals, and Senate Bill 7012 has passed 1 of its 2 committee referrals. I have my co-counsel and general counsel available for any questions, and I can also answer any questions that you may have on this current legislative session.
Thank you very much. That's a very concise and thorough explanation of some of these bills that we're following. I will, before I open up for board discussion, point out that in your packets, we have more bills of interest listed, and so, you know, you might want to check over there. It's a nice little longer list of some bills with issues that this board has been concerned with. Things like golf course best management practices and certification is in there as well. So, and gypsum stacks that we have been talking about here. With that, Commissioner Cohen, you're recognized.
Thank you very much, Madam Chair. I wanted to make a few comments on the dangerous tree preemption and ask a couple questions about that. When I served on the Tampa City Council in 2017 and 2018, we did a complete rewrite of the city's tree code and rules, and we did it because there was need for clarity. There was a real desire to protect the city's tree canopy and air quality, also to protect the trees because they play such a role in stormwater amelioration. And we worked with the builders and the neighborhoods, and it was really, really a comprehensive 2-year process. We passed a new tree ordinance in March of 2019, literally in the weeks before our council expired. And within a month, the legislature completely preempted everything that we had been working on. And the minute the law took effect, literally the trees started coming down. And we have all witnessed really heartbreaking sights in our neighborhoods. I just this week got a note in my mailbox from a child that lives on my block expressing concern about this beautiful tree that had just been taken down, that under the local rules never ever would have been allowed to come down. So what I wanted to ask about, it sounds like the repeal bill hasn't been heard by any committees, so that doesn't appear to be going anywhere. But on this second set of bills, Senate Bill 518 and 1555, which takes away some ambiguity and defines the risk, do these bills actually take us to a place where there is going to be an opportunity for local governments to at least have some effect on the tree ordinances in their municipalities? Because, you know, in the case of the city of Tampa, they track very closely where the tree canopy is, and they mold their laws to try to have respect for keeping it at a certain level. Are we going to see that come back again with these revisions? Is this going to strengthen the local governments?
Hi, Commissioner Cohen. So for Senate Bill 518, I think the most important thing is that they will be they're changing the standard from dangerous to unacceptable risk. And that's using a International Society of Arborists standard and using their best management practices as guidelines to determine that. So I think it clarifies where the preemption ends and local governments may step in, because if a single family property owner does not obtain the standing of unacceptable risk, they can't remove it without going through the proper permitting channels. But if they meet the standard and they get a arborist to certify that, or a professional landscaper, then they would be able to remove that without any sort of permitting requirements.
Well, it sounds to me like this is probably incrementally better than where we are now, but not where we were before the preemptions took place. So it's probably
Correct.
some progress, because I hope it's been widely viewed as a failure that these local laws have been preempted, but at least it appears that perhaps there'll be some improvement to the process.
Correct, and on that point as well, the definition of the residential property is being clarified. So I know that was a gray area that I think even City of Tampa went through some litigation for previously to identify what was residential property. And so now there's a clear definition that it has to be a single family detached home.
Thank you. And thanks for fleshing that out, Commissioner Cohen. I know it is really important to our constituents in our community, but at least we may be moving the needle, as they say. All right, and I thank you very much, Ms. Lee, and thanks for the additional backup that is also informative, and I'm sure we can reach back out to you all, as well as our own lobbyists, to work through some of that, but it's very informative. Thank you.
Absolutely, and commissioners, we always have the opportunity, if a bill is being fast-tracked or needs attention, to work with the chair to get subsequent information out. But you know, right now we don't have any direction to do that. But if something happens between our next meeting, obviously the chair would be notified and would make the decision if we needed to move forward.
Thank you. That's a good point, that if anybody has anything specific they really want to stay closely tracking on, that they could reach back to.
Correct, correct. And because it's always such a dynamic thing, and what happens at the end is everything gets thrown into a different bill, the bill's morphed, the bill changes, and you have 4 weeks between our next meeting, and you have no time to react sometimes to that. It's only happened, I think, 1 or 2 times that I'm aware of.
And I did have one question, and this may be a dumb question, but it's my chance to ask it. We, with regard to the Bill 569 and 620 about private entities being able to sue the government if the rules were deemed to impact them negatively in any way. That sounds so bad in so many ways, and be able to, not only sue the government, but sue for damages and court costs. Does that apply retroactively to all our local ordinances and our charter, or only everything moving forward? Mr. Marotti?
Yeah, no, they do not apply retroactively. They will be, and Ms. Lee can correct me, if July 1 or October 1, because both of these bills have different, the business impact bill and the business profit bill have different start dates, July 1 and October 1, so Beth can correct me. But no, they do not apply retroactively. It'd be for ones passed after that, but we'll let Beth, if she wants to weigh in.
Hello, yes, so the Senate Bill 620 is proposed to go in effect in the July. It's the local ordinances, Senate Bill 280, that has an effective date in October.
Thank you.
So July 1.
All right, thank you. And seeing no further questions or comments, Ms. Doherty will thank Ms. Lee and move to the director's presentation.
Thank you, Beth. And before I move to the executive director presentation, I did want to comment to Commissioner Cohen. Currently, the law, you're supposed to have a certified arborist come and inspect and deem that the tree is dangerous, or now it will become an unacceptable risk if that passes. But you do have a department within this county, Natural Resources, and the head of that department is a woman named Carrie Moore. And so they do take tree removal applications, but I'm not sure if they ask or have the ability to ask at that time if there's an arborist. And the reason I raise this is it's not only in the city. I live out by Lake Venonestassa, and there was massive tree removals when this happened. And then they came out and they charge, after the tree is removed, if there's no certified arborist, $65 an inch. And some of those fines were over, $10,000. But the reality is, at that point, the big grandfather oak is gone. The squirrels, whistling ducks, screech owls, are displaced, and the tree canopy is gone. And sometimes they go to a hearing, and they can actually be required not only to pay a fine or a penalty, but to replant trees. But it would be interesting to look at that form to maybe ascertain if you have the right to ask ahead of time if there's a certified arborist. I don't know, but I did want to let you know there is a process that people do apply for tree removals, and some of these individuals applied, but still didn't have a certified arborist, but by that time the trees are gone. So just wanted to bring that to your attention. There is a mechanism, though, within the county to go look at tree removal and to apply for a permit for tree removal.
I just wanted to say, and some people just actually decide to just pay the fine, and
Well,
it's not the right way to go about things.
You are exactly correct, Commissioner. Yes.
Just like gopher tortoise killing.
Yeah, not even it's with trees and with other things too, with permitting issues. But just wanted to, and I think Natural Resources for the county does an amazing job. That whole team, they do. It used to be Joe Gross, and now he's over in code enforcement. But Carrie Moore's been doing an awesome job.
We have one more commissioner in the queue, Commissioner Kemp.
I'm thinking about I've determined that whenever the state legislature meets, it's a state of emergency for Florida. And I hold my breath till the end, the tree ordinance being one that, I think has been a disastrous, ordinance up there or legislation. Obviously this business profit, $15,000 or more, is going to be huge in its impacts. I just had, I haven't even wanted to think it through quite, but just suppose, I'm just trying to think of a circumstance, but suppose newly, there's like some chemical you used to let go and think was harmless, and it turns out it's not. There's no federal or state law, whatever, but you determine that, and you try to make a prohibition about that, but that would affect the business of more than $15,000. So let's say you still decided to go forward. Are you on the hook for the first year prohibiting it, forever? How does that, do we have any idea?
Yeah, I think, and Ms. Lee can clarify, I believe it's up to 7 years of 15% of their profits, so not 15,000, 15% of their profits. So yeah, and it could be attorney's fees also, so you could be on the hook for a lot. So the idea is it's really have to decide, and case by case, where do we want to amend ordinances, and could it potentially impact business profits to the extent that it could then come back to impact the county's county's ability to regulate or pay
It
the
seems
fines.
also it might be very challengeable.
Yes.
Yeah, okay. I just
And-
kind of wanted to get I'm just slowly digesting the implications,
And-
not what,
Yeah.
reluctantly so. So,
And one clarification on Senate Bill 620, the business damages bill, it is actually, if it passes, it would pass upon becoming law. So theoretically, it could be a few days before July 1 or a few days after. It's one of those ones where they don't have a set date. Ms. Lee just clarified that with me, so
we should do everything in June.
possibly.
Commissioner Kemp, to answer your question about the damages, the amount of business damages specifically that's listed in the language of the bill is that, like Mr. Marotti said, the present value of 7 years lost profits or an amount equal to the business's gross receipts for the 60 months preceding the date of enactment of the amendment to the ordinance or charter provision. So it could be 7 years or 5 years roughly, depending on the circumstances of the case. An example that I've heard about for this ordinance is, especially with certain counties and municipalities moving to septic sewer conversion, if you have business that primarily deals in septic tanks, they may be one that might go forward and challenge and say that their profits have been lost by an ordinance that is converting septic to sewer.
Oh, thank you. I was trying to think of what obvious examples. I figured there would be something like that. I just started to, came up with a chemical, but thank you so much for elaborating. And I don't know whether you said the other part earlier. If so, I apologize, but my brain is resisting absorbing exactly the impacts of this. But that septic is an excellent example for Hillsborough County and what we're trying to do. And there's probably just all kinds of things out there that are, I couldn't even think of right now that we are bound to see. So, wow, is that a awful thing?
Yeah.
Okay, thank you.
Commissioner White, you're recognized.
Thank you, Madam Chair. I actually have two questions, and question number one is kind of a two-pronged question. I thought I heard you say that with Senate Bill 208 and House Bill 403, that land use policy would be exempted. I want to verify that I heard that correctly. And then I'd also like to ask if that's also true for Senate Bill 620 and House Bill 569.
Hi, Commissioner White. So for the Senate Bill 6280 and House Bill 403, it does specifically say county and municipal planning and land development regulations. So it's pursuant to a specific statute cited. I want to say it's Chapter 193, but I can double check that for you, the language in it. But it says land development regulations pursuant to a specific statute.
And is that, okay?
In short, the answer is yes, it does. Both the business impact statement bill and the business damages bill both recently carved out those exceptions for land use ordinances.
So any amendments to the comprehensive plan, land development code, none of those are impacted?
I'm not 100% sure about comprehensive plans, but definitely
Okay.
the permitting decisions, the day-to-day permitting decisions,
Okay.
development orders, if you will.
Got it. Okay, I can ask
double back
county
on the
staff
comp plan.
some
We'll double back,
further
yeah.
questions about that. Okay, and with respect to damages that might result from a charter amendment, how would a citizen-led charter amendment be impacted by that legislation?
Well, that's an excellent question. I want to look into that too, see how it's phrased. But in the end, it's still going to be a law that the county has to implement. So, but I want to make sure we get you the right answer. That's a great question.
Yeah.
Yeah.
Okay. Very good.
Thank you. I see no further questions. We'll again thank Ms. Lee for helping to inform us about what's going on in Tallahassee and answer our questions. And now move to the Executive Director's report. Ms. Lorton, you're recognized.
Thank you, Commissioner. I just have a few brief slides. If Mr. Brewer, or I think that's the person who has my slides, could pull them up, that would be great. The Executive Director Report, excellent. Next slide. Staff participated in the Fresh from Florida Ag Breakfast during the grand opening of the Florida State Fair. There were approximately 400 guests in attendance. Additionally, EPC is sponsoring a public information table in partnership with the Hillsborough Soil and Water Conservation District, which is located at their pollinator-themed exit in the Ag Hall of Fame building. We have free Florida native wildflower seed packets available for visitors who stop by our display. I'd like to personally thank the fair organizers and Betty Jo Tompkins, who's the Executive Director for Hillsborough Soil and Water Conservation District, for the opportunity to educate the public at this high-profile event about EPC and the important services we provide to protect our natural resources. Next slide, please. Hushang Bustani, our previous Waste Division Director, was EPC's cheerleader for a variety of philanthropic events and served as the Philanthropic Committee Advisor for many years. His love extended to animals as well as people. When he retired after 40 years of service with the EPC, we decided to memorialize the philanthropy he championed with the For Love of Bustani fundraiser event, which is to be held annually on or around Valentine's Day. EPC staff raised over $1,000 in personal cash donations and collected food, treats, bedding, and toys to benefit shelter animals in need. Hushang was able to join staff on Monday for the inaugural event as we presented the collected donations to Hillsborough County Pet Resource Foundation. I wish to thank everyone that made contributions for the shelter, and especially to thank the event organizers, Michelle Jenkins, Cody Winters, and Mary Guthrie, for all of their efforts. And that little dog up there is a brother to my dog. That's his dog, Hubu. He's much bigger now. But, and I do want to say, shout out to Scott and all the staff at Pet Resources. I've gone to Pet Resources for the last 4 decades to volunteer, to help, and I can tell you that facility is amazing, the changes it has gone through. And I also learned that you can donate food to Feeding Tampa Bay, dog food and pet food, because many people take their food and feed it to their pets. And so there's a whole different segment of Feeding Tampa Bay that works with Pet Resources to get some of these animals food and allow them to stay in their homes rather than be relinquished to the pet center. So thank you so much to Scott and his team. Next slide, please. Tom Ash spoke to the Hillsborough Organization for Progress and Equality, HOPE, regarding Tampa Bay and river tributaries in January. The topics discussed range from red tide to nutrient loading and littering issues, to educating the public on important environmental matters that they can become involved with. Tom will be addressing Leadership St. Pete next week at their Environmental Sustainability Seminar to discuss current environmental issues as they relate to the city of St. Petersburg and surrounding areas. He and a panel of water experts will provide the class with actionable takeaways on how to be a good environmental stewards for their city and communities as well as the planet. Next and final slide. Here are some of the other outreach events happening in the next few weeks. USF's Engineering Expo features hands-on exhibits that help encourage K through 12 students to pursue fields in science and mathematics. EPC has been a proud exhibitor at the expo for over 2 decades, reaching thousands of students. We are honored for our engineers and volunteers to be a part of this important educational event that is being held on the campus tomorrow. Tampa Bay Estuary Program is sponsoring a Give a Day for the Bay trash and debris cleanup along Bayshore Boulevard this Saturday from 9 a.m. to noon. Deanna Lee with our Air Division will be making a presentation next week to approximately 150 science students at Alonzo High School. Topics will include an overview of what we do at the EPC, as well as how to pursue a career in the environmental field and engineering. The Hillsborough Regional STEM Fair judging will be held on March 1st. I'd like to thank Sheila Loost with our Waste Division for volunteering to serve as a judge for this event. Many of the commissioners will remember that we bring the Environmental Merit Award winner that we select to this committee, and she will be selecting that committee for 2022. And we will also have them share about their project in receiving the award. And finally, EPC will be joining you, commissioners, at the Strawberry Parade lineup on March 7th. The last time we did this was actually the year 2020, March 2020. That was the last outreach event as such that we had done. So as in recent years, EPC is handing out our environmentally responsible wildflower seed packets. And next slide, please. And with that, our follow-up meeting, next meeting is March 24th, 2022. And that concludes my presentation, unless you have any questions.
Thank you very much. It's a happy crew over at EPC, and glad to see Hushang Bustani being honored in that way. That is so fitting for someone with his long years of service to EPC and this county. Great presentation, as always, keeping us informed, short and sweet, and I see no further board questions or comments. And with no...
Any future topics?
I'm sorry?
Were there any future topics?
That's what I was just about to ask, if anybody had any future topics for discussion they'd like brought back, but seeing none, we stand adjourned.
Thank you. We will be bringing, thank you. We will be bringing the noise back probably in March, the noise presentation. We're bringing the noise.
Thank you. Thank you.
Thank you, commissioners. Oh, again?
Yeah, well, this morning.
Oh, this morning, yeah.
Yeah.
Okay.
Yeah.
Oh. I got in.
I know, but the gate broke and they blocked it all off.
Oh, no. Can we get out?
Yeah, I'm sure you can.
Okay.